So, welcome to the second in a series of two podcasts on the overview of private acquisitions. Just by way of recap of what I ended with in the first podcast. In the last podcast, we were talking about the due diligence process and talking about the aims of the due diligence process, which are basically threefold. So you ask a whole load of questions and ask to see some key documents, usually across the whole spectrum of the different practice areas: employment, IP, real estate, and so on and so forth. And you do that for three main reasons. Firstly, to get an idea about the value of the company. That's not just an accounting issue, although that's obviously crucial and that's part of due diligence. But also, as you get to know the company, you can determine the price that you're willing to pay. Now remember, this is a private acquisition. It's not an acquisition of a public company where the share prices are traded and therefore known minute by minute, and you can use that as the basis for a much more scientific way of valuing a company. Even then, there's still big assumptions that are made, but here there's no such measure of the value of a company. So part of it is looking at the accounting side of things, which is done by auditors, but the other side of it is a technical due diligence, which looks at, in terms of the industry, how the assets function, what their strategy is like, and those kinds of issues. But us as lawyers come in as part of looking at tax and all the other areas, such as their contracts, their corporate governance, their disputes, whether their IP has been registered validly, who owns their property, in what way do they own the property. So do they own it as what we call a freehold, which is the highest type of estate, and the other type of estate is a leasehold, and for how long? And do anyone else have rights and interests over that land or over that piece of property, like a factory or a headquarters or a warehouse or a testing facility, or anything else? And those other rights could be mortgage rights. So in other words, someone has a debt, a fixed charge over that property. Is there a floating charge over some property? Do people have rights of access through your land, what we call an easement? Do they have a right to take stuff out of your land, which we call a profit à prendre? Are there any kind of limitations, what we call covenants, that have been imposed when you bought the land or when you bought the lease? So these are all important issues that accounting can't really give you the full picture, and that's why you have to involve both industry experts and lawyers. And that is all goes towards trying to decide what you, the buyer, are willing to pay for the target. And when you identify problems and issues, it then makes it very difficult, morally at least, for the seller to argue with you when you say, well, look, here is a series of liabilities. Actually, the factory, you may own it, but other people have a right to walk around the car park, and that creates tensions and difficulties and so on. And that just gives you ammunition in order to carry out your negotiation. Crucially, for lawyers, our role is to propose contractual and non-contractual mitigations in the purchase agreement, and this is really the main part of what I want to talk about in this second podcast. So I'll say very little about it and get to the detail when I do. The third factor is, the bigger the picture they get about the target, the better that helps the buyer get an idea about how best to integrate the target into their business. Now, obviously, they've thought about that to begin with, because they've obviously thought, well, this could work with our business, otherwise they wouldn't be doing the acquisition. But the more detail they get, the more detailed their thinking about integration can become. So just a bit about the purchase agreement. If we're structuring the deal as an asset sale, then it's known as an asset purchase agreement, an APA. If this is a share sale, so buying the whole company, we call it an SPA, a share purchase agreement. In England, at least, if you're buying a company, you literally only need one document, which is something called a stock transfer form or a share transfer form that you may have encountered already in other modules. And that's simply saying, the current owners of shares are going to transfer them to the new owners. And that is literally it. That is all you need to transfer a company. And you'll do so, and it will say that you're doing so by giving a full title guarantee on the shares, so that you own the shares both legally and equitably. The situation for an asset sale is trickier because some assets, particularly land, require certain formalities. A transfer, or what we call an assignment of land, needs to be done by deed. It needs to be formally witnessed in particular ways, and there are certain formalities that are important to other types of interests in land, such as mortgages and easements and leaseholds and so on, and likewise an assignment of intangible property doesn't have to be done by deed always, but you would, in something so important, obviously do that by contract. Again, you'd expect to get full title guarantee for the main assets that are subject matter of the acquisition. So the next few slides talk about how we mitigate risk contractually within the purchase agreement, whether that's an asset purchase agreement or a share purchase agreement. So one of the ways is by having warranties, and these are promises by the seller about the target, and they tend to be organized by topic, so intellectual property, real estate, chattels, employment issues, HR issues, and so on and so forth. The due diligence process is the basis, the answers from the due diligence questionnaire that the seller gives you are the basis for the warranties. So, for example, you could make a promise that the only dispute in relation to the land you're buying is the following. Or you could say there are no disputes, if that's the case. You could say that the machinery contained in the farm, and you could list it, we own that in full. That's an important guarantee. And you could say something about the state of repair of those assets. Now, a warranty has to lead to loss. So if you breach it, if it turns out what you said is incorrect, that's not enough to then sue the other side. You have to show a loss, okay? And in some cases that's really easy given the nature of the thing. So obviously if you've promised that important machinery is given under full title guarantee and it turns out someone has an equitable interest in it, obviously that is a significant loss in value and you won't have any problem suing. Just to give you a sense, a very basic, simple acquisition of a small business or a shop or something, the warranties could be up to 5 pages. In a much more complex deal, the warranties could take more than 30 pages. We then have something called a disclosure letter, which is an annex, and it's an exception to the warranties. So why not just put them with the warranties? Well, sometimes negotiations for acquisitions take months, especially for significant size ones. They always take months. So what might have been true while you're negotiating version 1 of the purchase agreement may no longer be true in month 7. So to make things easy, there's usually a disclosure letter it's called a disclosure letter. It's just an annex to the purchase agreement. We just call it a disclosure letter. And it'll have exceptions to particular warranties. And just to give you a sense of how big that is, it's usually something in the region of 4 pages. So you don't expect to make loads of amendments, exceptions to the warranties once they've been agreed. So another way we mitigate risk within the purchase agreement is to provide for indemnities. And this relates to a situation where the seller agrees to compensate the buyer in the future if an event happens. So, for example, due diligence reveals there's litigation against the target for £1 million. So, one of the first things, given that's a lot of money, one of the first things the buyer will do is say, right, okay, I want to see all the advice you've had from, your lawyers and, any advocates or barristers that were involved. And you say, right, well, what do you think is the worst case scenario? How much will I have to fork out if I lose? Well, it'll be £1 million. Fine. So in a share sale, obviously we're talking about a share sale here with litigation, you then put in a promise that providing the buyer defends the action and does so diligently, the seller will compensate the buyer if the court finds against the target. And they'll do so up to, and usually you specify a figure. So here it's £1 million. So this is important. You can't just put a whole load of indemnities for everything that you see. You can't say it has to be an identifiable issue, or else the seller will usually just refuse to give you that, to agree to an indemnity. So it's for a future event. Almost always when you're buying a company, there will be an indemnity for tax, because tax is paid, I think, 8 or 9 months after the financial year it's due. So there's a time limit, and you never know what that liability will be, or usually don't know, because acquisitions don't always take place once you've figured out what your tax liability is. So in most cases there'll be an indemnity that says, if our calculation for the tax is different to what HMRC is going to ask for, then I, the seller, will indemnify you for the difference. Okay, so that's a pretty standard indemnity that's always there. And the other example is for litigation, any kind of dispute, court or arbitration that's identified. You'll come up with a figure that you both agree on as to maximum liability. You'll get the buyer to agree to defend the action diligently, right? You can't guarantee the outcome, obviously. And providing they diligently defend it, then if the court finds against, the seller will cough up. Now, there are some things that are so crucial, they are what's known as conditions precedent. So these are issues that will be identified either in due diligence or because they're regulatory issues. And they are conditions precedent, which means that the buyer will not pay any money and the rest of the agreement will not come into force until these issues are solved. Now, they usually involve things like merger control, so where competition authorities have to give the thumbs up to a particular merger. That's a condition precedent usually. And if you have an agreement, if the target has an agreement with a third party, say the target's an asset, right? So factories, and you want to get the supply agreements and the distribution agreements that relate to that factory. Obviously, they're in the name of the seller. So you have to do something called novation, usually, whereby you get the seller and the third party, the supplier or the distributor and the distributors, to agree to novate the agreement in your favour, in the favour of the buyer. Now, that may not be a condition precedent if it's a small contract that's insignificant, that can be easily replaced. But if it's an important contract that's crucial for the business, let's say, a customer that takes 20% of the stuff that's produced in a factory, you want to make that a condition precedent. So what you're saying is, if I, the buyer, cannot convince the third party to enter into an agreement with me, this deal's off. Now, the seller will usually say, right, you need to start entering into negotiations with them ASAP to make that more likely to happen. But if it's crucial and it hasn't been resolved when the contracts are signed, the buyer may insist to put that as a condition precedent. So far we've really talked about issues that are warranties, indemnities and conditions precedent, that are ways of mitigating the risk if you're acting for the buyer. For the seller, they obviously want to limit the scope of all these promises. Okay, they want to limit the scope of the warranties, they want to limit the scope of the indemnities, they want to limit the condition precedents that could scupper the deal. But there are other things that they can do, and one of them is called a de minima clause and a de maximis clause. So de minima clause says, look, if there's a minor breach of warranties, or then you can't sue me unless it reaches a certain threshold. And a de maximis clause basically says that I'm not going to be liable for more than X amount of money, and it tends to be a percentage of the purchase price. And again, these things are up for negotiation. You then have what I'd call non-contractual mitigations in a way. And the most obvious is, walking away. I haven't talked about changing the purchase price, but that's, implicit in what I've been saying. That's an important mitigation. You find a risk of litigation. Say the seller may say, look, if you think this is a problem, let's reduce the purchase price by £1 million. That's another way you can do it. But if you find huge problems, you walk away. And kind of things that may mean that is if huge liabilities are identified, like product liability that's going to cost you a huge amount of money, say breaches of the law that are going to cost you a lot of money, kind of things that would be deal breakers in my experience. So cartels, if you find that the target is involved in a cartel, that's one up from theft. So huge reputational hit, loads of fines, usually from a competition authority, and you get sued by people who you have overcharged. So walking away is a mitigation, right? It's the nuclear option. I've touched on this in terms of innovation, but important commercial agreements can be either assigned or novated with the permission of the third party. And again, this in a way is a non-contractual thing because it's not part of the purchase agreement, but you try and get those in place before you agree to sign the contract, so that you have an idea, like, do I have an energy contract with energy provider? Yeah, why would that be a problem? It wouldn't be. They'd happily provide you with that service. But where it comes to a key client, customer, they may take that opportunity to change the terms of the existing contracts. They'll say, all right, I'll agree to novating the supply agreement, but I'm going to have to charge you 5% more. Okay, so you have to do all those kinds of negotiations as early on as possible. Where we're dealing with assets and where we're dealing with leaseholds in particular, one of the most important things is to get, because a leasehold is a contract between the target, which is the lessee, and the lease, the landlord. And most leases, especially of commercial property, require the authority of the landlord in order to either subcontract or to sell the lease. So let's say a lease is 99 years. You're only year 10 into it. You've got 89 years to go. There may be a clause in there that says that the landlord has to approve any subletting or any assignment of the lease. So you have to get that agreement in place if that's the case. So all this is a mitigation of issues you've identified during the negotiation, and in particular during due diligence. A bit about what happens in a cross-border situation. Well, you have like a framework agreement, a purchase agreement, APA or CPA, SPA, depending on what we're talking about. And it's usually subject to neutral law, but not always. It depends on, which party has the most negotiating strength. Statistically, the most common are English law and New York law, both common law systems. And actually, increasingly, Hong Kong law, which is also a common law system, but is favoured by where one party is Chinese and another party isn't Chinese. They may, obviously, the Chinese company may impose Chinese law, but if they've got equal negotiating strength, they tend to go for a compromise, and Hong Kong law is very much based on the common law system, so it's well known by arbitrators. So that's an example where, say, you've got a company that has assets in 3 countries. You'd want to have a purchase agreement in each country, especially in relation to land, because each country has its own formalities in terms of land. So you need to have an agreement there, and also because each country has a different way of registering shares. So again, you'd want to have a domestic agreement there, and then a framework agreement coordinating everything together. So I promised at the beginning of the first podcast, I'll talk about the enforcement of the purchase agreement, the asset purchase agreement or the share purchase agreement. And it's important because quite often when you send off, say you're acting for the seller, and you're their lawyers, and you send off the due diligence questionnaire you've received. Sometimes, depending how it's handled by your client, the managers just don't get why this is important. They think they can just exaggerate or estimate and something like that. So sometimes you get back in due diligence reports information that is not very accurate or not complete. Once you then start populating the purchase agreement with the answers you've been given in due diligence, and then send it back to the client, it tends to concentrate people's minds, especially when you explain that actually this stuff is potentially enforceable. Most mergers, not all of course, but most are governed by a particular law, and usually the forum is arbitration rather than litigation. So arbitration is a private forum. The parties choose their own arbitrators, their own judges, essentially. Usually, depending on the system, they don't publish their decisions, they just publish it to the parties. So you get you get speed, you get very unlikely for it to be appealed unless the arbitrators have really done something manifestly wrong. And it's enforceable because most countries are party to something called the New York Convention on the enforcement of judgment and arbitral awards. So an arbitration award agreed in Edinburgh or London or Lagos or Cairo can be enforced wherever the assets of the target are based, of the seller are based. Most countries are party to this agreement. So usually, as I say, our enforcement is done by arbitration. That's just a statistical comment. There's no reason why they can't give jurisdiction to courts, but they prefer to keep this stuff, while it may be costly to do arbitration, it's quicker, it's more confidential, there's no appeal process really. And as long as the order is enforceable in the relevant country, then that's the most important thing. And law is usually a matter of evidence. Okay, so if you're saying I'm going to enforce English law, the ideal thing is you have, one, two, or three arbitrators who are all experts in English law, in which case you don't really have to prove the law. But if you select French law and for some reason you have two French lawyers and an English arbitrator, you hope that person has French law experience, English law experience, or else it's not clear why you choose them. And local enforcement will happen. So, wherever the dispute is, as long as your convention applies, then you can enforce the issue in the local courts. Sometimes you might want to go directly to the local courts. So you might say there is non-exclusive jurisdiction of an arbitration tribunal to allow for the possibility of suing locally, especially for property. Again, that's very important that's usually done locally, because the last thing you want is the arbitration tribunal to get the law wrong, and then that's a basis for appealing it domestically. Anyway, point is of all this is not a course on a private international law or conflicts of law, but the point is that these agreements are enforceable. If we're talking about a purely UK acquisition, obviously the English courts have jurisdiction, unless you say it's arbitration, and then it's obviously going to be arbitration either in London or in Paris, depending on the system you use. So just to be clear, if we're buying assets, it's called an asset purchase agreement. If we're buying shares, we're buying a whole company, it's called a share purchase agreement. And generically, we just refer to that as a purchase agreement. I said at the start that we do this kind of private acquisitions in two ways, and kind of so far I've been talking really about a private treaty, two companies who've somehow identified each other or been introduced to each other by one of their advisors, and they're negotiating exclusively for a period of time. However, it's very common to also have an auction or a beauty parade, and that tends to be where you're hoping that some of the financing for the deal is going to come from a private equity company. So in other words, you've got a buyer and a private equity company together buying a target company. Now here, the seller will effectively do due diligence on themselves, and they will publish that in something called a virtual data room, which is how due diligence is done anyway. So when I said a questionnaire sent out, it is, but then usually the answers and the contracts you've asked to see are put in a virtual data room. So that's an intranet site that's password protected, and only named people in the deal can access it. So you'll have the seller will populate it, they'll get their lawyers to do that, there'll be named people, we'll know who they are. The buyers who are reviewing it will have a deal team, so they'll have, depending on the deal, 4 or 5 corporate lawyers, 2 tax lawyers, 1 or 2 competition lawyers, etc., 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 and they'll be named, and they'll be part of a deal team, and only they will have access to the virtual data room. In an auction sale, what happens is, because you're obviously putting yourself out there, putting the target out there, it's the seller who will prepare sort of typical due diligence. Okay, and how much they want to do is really up to them. But the more they do, the more the fuller it is, and the better for the auction process. The less they do, obviously, the less secrets they're giving away. So it's a balance. Again, law firms have precedents for this, and they have typical questionnaires that they would do in an auction process. So they will then automatically put the answers to their own questions, if you like, in that virtual data room. People will come along, and again, they'll be named, you'll know which companies are involved, and they will inspect the data. And so these people have to be approved by the seller. So the seller can decide, look, I'm only interested in these 3 companies. But to do that, they need a long list, and then they whittle it down to a short list, and obviously the buyers may pull out once they read the due diligence. The seller also prepares for something called an information memorandum, which is basically like a sales pitch, if you like, for the target. And they will use that to then populate the share purchase agreement or the asset purchase agreement, usually a share purchase agreement. And the final thing is a bid process letter, whereby the whole process is set out and everyone who wants to be part of it will agree to it. So those 4 main components will relate to the employees, the assets and the liabilities, and corporate governance. And there'll be an accounting element as well. So we said at the start that in the beginning we're thinking of how we structure this deal. Do we do it by just the assets, or do we buy the whole company? And as due diligence happens, that may change our understanding. In some cases, there's no choice. You just want to buy a large single asset with perhaps some peripheral assets, and that's it. And that's not going to change. Quite often, it's usually where you start off with a share sale. You want to buy the whole company, but you find out that there are significant liabilities, so you switch to an asset sale. And sometimes you're dead set on a share sale, and you're not going to change no matter what the liabilities are. You're just going to change the sale price. Okay. So some ideas on the pros and cons of each. So with an asset sale, you get to cherry pick. You're buying discrete assets. The liability remains with the seller. I gave the example of a factory owned by the seller that produced dodgy goods that harmed people, and therefore they're being sued by those people. Anyone else who's already been harmed by that company will continue to sue that company, irrespective of who now owns that factory. So if the factory then moves to become owned by someone else, the liability does not follow the asset, right? So that's the big advantage of asset sales. Now, there's a big problem with that, where we're dealing with assets that have some kind of mortgage or charge on them, because the mortgage or charge attaches to the asset, not to the company. And hence, you need to discharge that mortgage before you buy the asset. It's like, buying a flat or a house that has a mortgage on it. The mortgage links to the flat or the house. So that's why it has to be paid off with the proceeds of sale, or with something else, with other money. And that's why usually when you buy a flat or a house in the UK, whether in Scotland or England, the lawyer acting for the buyer also acts for their mortgage company, to ensure that the mortgage of the seller has been paid off. Okay, so the issue of liability, we're talking about liability to do with taxes, to do with litigation. That doesn't follow the asset. But a mortgage is linked to the asset, and it actually prevents the seller from selling it without their permission. So the only way they can do that is by paying off the liability. The big advantage of an asset sale for the seller is it allows them to get rid of assets that they no longer need. And it may be for strategic reasons. It may be because they want to refocus their activities. And we'll see a case study like that, where a company wants to refocus its activities or concentrate on other activities, so it sells some of its assets. And, that downside of that is, of course, that the liability remains with you. And that may be a problem if loads of people are suing you, but it may be no problem at all if, there is no liability that comes out of those assets. For the purchaser, it's great because they choose what they want and what they need, and they then get those minus the liability. So they get it free of any liability because any mortgage will be paid off, any charge will be paid off, any liability that's to litigation or tax stays with the existing seller. So from the perspective of, buyer and seller, buying the whole company has some advantages as well. It's pretty much the converse of what I've just said. It's a clean break for the seller and it removes liability. Having said that, as we've discussed, the share purchase agreement, usually the buyer will want indemnities for tax and for pending litigation or arbitration. Whether they get them is always up and their scope is always up for negotiation. Most, the advantage of, the role of a lawyer is to tell people when to fight and when not to fight in a negotiation. It'll be very, very difficult to convince a buyer to not have something about tax liability just because, it's not really within their control how HMRC interprets policy, right? So that's something that you'd want always in there. Arbitration and litigation is always subject to negotiation. You can have an indemnity in there, or you can just reduce the price that you're thinking about. For the buyer, a share sale makes more sense if you need most of the assets. So then you don't have to worry, have I got all the assets that I need to make the main assets I want to function? It makes things a bit more straightforward. So let's try and bring all this together in terms of what we've discussed in the two podcasts. So once negotiations have started off, it's almost always the case that there'll be a letter of intent or a memorandum of understanding or heads of terms, call it what you want, which is largely non-binding. It's a roadmap of what has been agreed and what hasn't been agreed. But there tends to be three clauses that are binding. The exclusivity, the idea that this buyer and this seller will negotiate for the sale of a target business, which they'll define, for a period of time. And they'll, if they haven't signed a confidentiality agreement at the same time, they usually have a condition that they will sign one, and they usually, to make that binding, put the form of that in an annex. And they'll say that this is subject to English law to ensure that this whole document, other than those three provisions, is non-binding. Then you'll have a confidentiality agreement. You'll think about the deal structure. Again, in some cases, you know exactly what you want the whole company, or you want just discrete assets. The buyer then sends out a due diligence questionnaire, and the answers come back from the seller about the target, and that's put in a virtual data room, which only named people can access usually. Based on that and anything else you've learned, the buyer then takes a first cut at drafting the asset purchase agreement or the share purchase agreement. And here they're looking at what to do contractually to mitigate the risks that they've identified. And there are certain non-contractual things that they can do as well. Once they've done that now that whole process is a way of garnering information. Because once you send over a draft, now these drafts can go on for months, right? So you can end up with, draft 20 or draft 30. it's an information gathering tool as well. Because as I said, the answers to due diligence questionnaire is not the end of the process. The next stage is for the seller solicitors to send their clients the copy of the share purchase agreement, the draft of the share purchase agreement or the asset purchase agreement. And they'll send all the IP stuff to the people who deal with IP. They'll send all the real estate stuff to the estates teams. They'll send the employment stuff to the HR team. And then all of a sudden, if they hadn't taken this process seriously, they begin to take it seriously at that point. And then people will start amending the drafts to make it more accurate. And that's where it becomes a useful tool for gathering information. So let's say you've asked about the state of the robotics in a car factory and you haven't got an answer. So what the buyer could do is put a warranty that says all the robotics in this particular factory are less than 3 years old and and have been regularly repaired and are in an excellent state of repair. That will then concentrate the minds of the sellers when they get that. So the people who are the engineers who are responsible for maintaining those will look at that and go, hang on, that's not right. We've got some that are 4 years old, so we'll amend that. So it'll be, all the robotics are less than 4 years old. Actually, we haven't we haven't checked their maintenance in the last year, so we'll amend that bit. And then they get that back, and then the buyer then gets more information about the state of the property. Now, the seller could just put a line through that whole thing, in which case that sends alarm bells. Why isn't the seller willing to say that the robotics in the car factory are in an excellent state of repair and have been regularly checked and are less than 3 years old, or whatever it is they're looking for? So it's an information gathering tool, as well as, in addition to, the due diligence questionnaire and the due diligence process in the strict sense. So as you're doing that, you then have to finalize the structure of the deal. And usually you do that at the stage where you've received the due diligence responses. So you've got that process there, the overview of the process. And depending on, the complexity of the deal, how much property is involved, how much people are planning to buy this company or these assets for, this could take a month, it could take a year. And most things take somewhere in between. Huge amount of documents, huge amount of information flowing, usually coordinated within the corporate department. And as I said, all the teams, everyone, real estate, competition, tax, finance, so on and so forth, IP, all have a role to play in the merger process in a law firm. That's why it's quite important to know about it. I hope that's been useful, and thanks for your attention.